Hello, Lyric Armstrong, your real estate agent and advocate. I am tired. So my voice is tired. I'm sorry for the sound of my voice being tired, but I wanted to get into some of the developments of YSL Young Thug case, and I hope you can hear me well. The July 1st will be a very pivotal moment, so mark your calendar for that. Law and Crime probably will be a good outlet for you to watch live. We'll recap it sometime later if we get the outcome, but they'll be doing in-camera review relative to some evidence. But what I want to go over today is the reason that brings such a pause to why the state worked so hard to bring a witness to the stand and now wants to impeach the witness. Now, the witness I'm speaking of is Little Woody, Mr. Copeland, the gentleman who expressed he had no interest in the truth unless, or I guess the better way to exclaim it is that in fact he expressed that he had lied to the um, to the detectives, and he was on the stand and could not remember what he told the detectives because he had lied to them so many times, and anytime he spoke to them, he gave them information only to protect himself from being prosecuted. That's information that Mr. Copeland gave on the stand. We have an affidavit from Weinstein that is in the motion to recuse, where it is stated in ex parte hearing that Copeland further asserts that he is willing to lie on the stand, and that ADA Hilton is not moved by this, shocking piece of information from her witness, so much so that she is, her and the judge is being alleged to pursue this witness in having him testify, even though there may be issues with him lying on the stand. We talked about how that is an unethical procedure, that ethically ADA Hilton is not allowed to put witnesses on the stand that they knowingly are going to be, false accusers or purport lies outright, that they have to have some faith in their witnesses. So not only does ADA Hilton, if all things reported in the ex parte hearing are correct, not only is she aware that her witness is unreliable, she furthers by putting him on the stand, presses to the effect, and now here we are in present day, and she wants to impeach him for in prior statements. All right, so let's get into court. Let's see what's going on. This is going to be some of, oh, sorry for the crazy background here. This is going to be some representation when you can say, all right, Your Honor, I can trust you on this one from what I saw. So I'm gonna go ahead and like and thank Law and Crime Trials for making this readily available to us. And my computer is doing things very odd, weird, and annoyingly so. So let's see if I can. Oh, oh boy. Yeah, so my computer wants to be weird. I hope it's not weird for you, but it's definitely weird for me. And it's making it hard for me to come on screen. So just give me 1 second to hopefully fix the technical difficulties that I'm having. Tell you what, let's do this. Okay, I'm back. Hopefully we're fixed. Let's turn ourselves up. Well, maybe not too loud because it is late. Sorry, guys. Life is life and things happen, right? So because of life being what it is, things happen and you just don't have the time you want to like sit up and go through all of this all day long. So I'm sorry it's so late. Made with precision. My editor is going to have a field day. And if I have to edit this myself, you guys are going to hate it. Sorry. I'm sorry up front, just in case it's me. Okay. Let's fast forward. Good goobity goo. Okay, here we are. All right, Judge. We're here. We're going to give the judge another opportunity to show us his judicial prowess. Okay, we're working hard to give him the benefit of the doubt. But I will say, this is probably to some degree a boring part for some because all the salaciousness of a trial happens when there's a blunder or there's an ex parte hearing, secretive meeting that doesn't get disclosed, but Brady violations from which could possibly be the case. So anyway, um, this particular part is important to be made aware of because this is how um, jurors can come to a conclusion that the general public feels is so off track because they can only consider what is given to them in court. And these type of motions not offside, but outside of the jury kind of framework what is given to them. So these are evidentiary motions that are getting ready to be played. Oh, if you're plugged in, I would unplug because something about law and crime speed or the microphones of the court, something about their feed is giving a buzzing sound. So don't put this in your ear because it will hurt. And it's not on my end. I cannot control it. That feedback there is continuous throughout. I'm going to try to speed this up just a little bit. Okay, we're doing roll call. Wait, roll call. It's really not that, it's appearances, but same different. This is the adult version of roll call. See? Where are the people? I cannot hear him at all. I have no idea what he's saying. Okay. I hope the court reporter can hear him. I cannot hear him, but he just allowed substitution of counsel basically for the purpose of the hearing. And maybe it's, I don't know. To me, all aspects of this case are highly important, but reality is emergencies occur. And so, if your attorney can't be there and they have a substitute for whatever the reasons, that is kind of reasonable too. It's just that what comes into evidence and what comes out or does not become a part of the evidence displayed before the jury are very important parts, very critical parts of the trial. So I would really prefer him to have his regular counsel there, but he does not, and he has okayed that with the judge. Now, one of the other things to take note is I think I called the gentleman Ben Steele. His name is Brian Steele. So I do apologize for that. Um, the B just became Ben. So I apologize. I probably was thinking about Ben Chu or something, but his name is Brian Steele. Okay. Sorry, Mr. Steele. So I should stick with the last names only. He's seemingly, I don't know where he is, but the other co-counsel is the one that's arguing. This is why you have a split of the case, the workload. Some will argue motions, evidentiary, some will do discovery, some will do certain witnesses, expert testimonial, cross examinations. So it helps to have more than one attorney to split the workload. And that's why Brian, that's why Mr. Steele was so adamant that he needed to be present. And the other gentleman was adamant that, just because he has two counsels does not necessarily mean that one can be absent at any given time because, they have split the workload and they have differences, different points of familiarity with the case. All right. So what are we doing, Your Honor? We're ready. Like my big gulp. This is obnoxious of me, so I apologize. I'm going to take this down to normal speed. Just because Mr. Adams has a cadence that is a good cadence, but the judge's cadence sometimes is slower, and I'd much rather us not waste a lot of time, but let's just hear him out. Okay. Like it's so crazy. There's a mic on that's giving feedback, but yet the mic that she should be speaking into is not on, so we can't hear. But we can hear a whole lot of whistling. So annoying. Thank you. Speak into the mic. We can keep up, right? We have ears. Her bottom line is okay, so what just happened basically is that there's a piece of evidence that they have come to an agreement. In civil, we would say we stipulated to. I think criminal would say the same. It's just the adversarial sides have agreed upon something. And in this instance, they have agreed to omit, to redact certain evidence. And she has to account for where this is within the video, the timestamp of it. So it's not just I guess there's a transcription that they're going off of. Each transcription has a line number, and then she's also giving numbers relative to a recording. So it's not played. This is tedious. This is secretarial work. This is paralegal work, the assistant's work, going through and putting evidence, putting evidence in order, knowing what the timestamp is, so that the attorney can purport it to the judge, you know, in real time. That happens with a good set of assistants and a good team behind you. So sometimes that's extra attorneys, that's the paralegal, that's the what should I say, secretary sometime. Um, but that's a lot of tedious background work that we're seeing kind of unfold in this hearing, in this motion hearing right now, evidentiary hearings. Okay.
they have to lay the foundation by asking now this prosecution says, because what happened then, if you notice, is they're playing the video, and essentially the testimony is coming out based on this audio as opposed to him testifying about it, but it denying this.
So there's information that's being relayed here is a good argument. I just don't think that he really is going to keep it out because um, ADA Hilton has spoken to Copeland about his recollection of many things, and his statements are varying. He actually states that I don't remember anything I said to, I think it was Officer Tug. I don't remember anything I've told the police officers. Yeah, I probably said that, or no, I didn't say that. And then they played a video of him talking about FaceTime, right? So, um, Mr. Copeland has been a little evasive or lacks the memory of prior statements. And so there are hearsay exception rules, which have to do with inconsistent statements, and they also have to deal with not being offered for the truth of the matter. So sometimes you'll have a hearsay exception and you'll hear, but Your Honor, it's not being offered for the truth. That the information that is being entered in that someone else said as hearsay is not to the truth of what they're saying, but it only just speaks to why the witness or individual did the next step or said the next thing. It speaks to their state of mind, what they were understanding at the time, and what they believed to be true, whether it was true or not. Further, in Mr. Adams' argument, he's saying there's a lack of foundation to bring in this testimony, that they haven't asked the witness direct questions in the courtroom to probe further into this previous set of statements. Sounds like interviews, or if it's transcribed. Well, no, you can transcribe interviews too. I don't know if it's depositions or not, but most likely most likely is the interviews that he's had with the police officers, the recordings of that. Well, the reason that though Mr. Adams is eloquently stating his objections, I don't think that they're going to land well, just because Mr. Copeland already said he lacks the memory of what he has previously stated because he lied. So that's the foundation of bringing in the evidence, right? Actually, is that he doesn't know. So we need to bring in the evidence to find out what he said before and see if it has consistency with what he purports to current day testimony. However, Mr. Adams' statement about direct questioning so that it can be done in the presence of the jury is important. More likely than not, the testimony of a witness has to be live. If it's a trial without the jury and it's only by judge, that's fine. But the witnesses have to come in and testify. So you can't just use their deposition because of the ability of cross-examination, because of the right of the defendant to confront their accuser, or as we spoke, confront does not mean to like chastise, but to ask questions of their accuser to actually probe further and see if they can defend themselves against such a accusation. It needs to be before the fact finder. So if the judge is not the fact finder and the jury is the fact finder in a jury trial, then it needs to be before the jury. If you're not having a jury trial and you're having it tried by judge, then the judge would be the fact finder, and he would be the one deciding. So anyway, Mr. Adams' arguments are salient. They just have a lack of applicability, or application, I should say, to this particular circumstance, in my opinion. But we'll hear what they say.
Okay, fine. So
Gosh, that whistling is so unfortunate. Because one of the Mr. Adams stated is that, some of the people that Copeland is relying on information to relate to the police officer, or at least he's saying that he's relying that information on, they don't have the ability to examine them because they are co-defendants, and the defendant has the right, or the accused has the right to remain silent. So that's what that's about.
Donovan Thomas was killed. We did in fact ask Mr. Copeland about that. Your Honor, when I had about guns. We did. So, Your Honor, on June 13th, we actually asked this series of questions. And this is all in relation to the night that.
So this is foundation.
A question to him was after the Mechanicsville, did you go anywhere after leaving Mechanicsville from what you remember? Yeah, you remember where you went? Pick little D up. Okay, and which little D are we talking about? The one that always be with me. Okay, is that the little D you referenced as your son? Yeah. Do you remember where you picked little D up? Where did you pick him up at? McDonald's. Where was the McDonald's? On Cleveland Avenue. And when you got to McDonald's Cleveland Avenue, was there anyone else with little D? Just him and Shannon. Anybody else? Just him and Shannon. When you picked up little D, what did Shannon do? What do you mean? You said you picked little D up. Did you also pick up Shannon? I said I picked them both up. When you picked up both of them, where did y'all go? I blanked out after that. You blanked out after that. Okay, why did you blank out? Because they were saying that I got the phone call. Do you remember who called you? So I asked him what occurred in the car. What's happening? He says he blanked out. So at this point, if he blanked out, he does not remember anything that happened in the car, which would be the conversations that he had with little D. And well, what he's now saying Shannon, but previously he told the detectives that Nard was in the car with him. And I believe that I asked him further on, and don't have this part of the transcript, did Nard ever get in the car with me? He says no. So, Your Honor, we have confronted him as it relates to what occurred. Let me go further. Excuse me. I'm going to go down to the transcript. Now, before multiple calls, did you, Shannon, Little D, have any conversation about that being killed?
Nespresso presents some that goes on and on and on.
No, was his response. Did you, Shannon, Little D, have any? Go further. Excuse me. I'm going to go down to the transcript. Now, before multiple calls, did you, Shannon, Little D, have any conversation about that being?
I'm glad she did. Just because I don't care for any any attorney's recounting of the statements, especially after seeing the way she interviews or asks the witness these questions. He would say one thing and she would turn around and make a whole statement as if she was doing cross-examination. Direct examination are open-ended questions. Tell me what happened. What did you do on this day? How do you know these people? Not closed in yes/no questions like, do you own a gun? Did you shoot this person? Typically the direct examination is left for narrative by the witness, whereas cross-examination is not meant to have narrative by the witness, and it's for yes and no responses. Therefore, the context is really presented by the attorney. She would ask him a question and Copeland would say things like, I don't know what you mean, we're cool. And then she would say, okay, so you've had a coolness for 10 years? And he would say, no, about 90 days. But from 10 years ago, you guys knew each other, and now that's 10 years later, right? Isn't that a 10-year time frame? And he would say, I don't know what you're asking of me. I was in and out of jail. We've been cool mostly 90 days in true interaction. And she would say, okay, so you guys have known each other for 10 years. And that restating his testimony and kind of expressing it the way she wants it expressed is improper, indirect. So I definitely don't like her trying to purport what he said. Just read the transcript. And if you don't have it in the transcript, then don't quote it, summarize it, but don't quote it because you don't know what it is. In my opinion, I don't trust her recollection. Not that she forgets, but her representation of what he says, I don't trust it.
That's a complete contradiction to that's impeachment by inconsistent statement. That he said no, they did not have any conversation about nothing killed. So
there you go. So we figured out why it didn't matter to her if he was going to be an honest witness or not on the stand, because she knew he had already stated that he lied or was untruthful in the past. And she has the goal of impeaching him due to inconsistent statements. Ever wonder why pleading the fifth matters?
What occurred? Let me go further. Excuse me. I'm going to go down to the transcript.
This is why pleading the fifth matters.
Shannon have any conversation about that being killed? No. What is the response? Yeah, it could be contradiction to impeachment by inconsistent statement that he said no, they did not have any conversation about nothing killed.
And when I say, do you wonder why pleading the fifth matters? Having the ability to protect yourself with the Fifth Amendment is very important. It is something that is not widespread. This is not something that every other country adopts. So having that privilege in the United States should be guarded. We guard the First Amendment with our life. We spewed out all kinds of nonsensical statements, and we base our ability to do so off of the First Amendment. But the Fifth Amendment in and of itself is a very valuable protection. Now, what gets me further interested in the ADA's position on this particular witness is this witness had an immunity deal. It's filed under seal. At least that was what they wanted. So I'm pretty sure they got that because it's reasonable to request it to have it under seal so that no other outsider can be privy to what the deal is, at least while trial is going on anyway. And consequently, so if you told the man you didn't care if he lied on the stand, you weren't going to prosecute him, but now you're going to impeach him for inconsistent statements, it's almost as if he should have remained his resolve and pled the fifth and went to jail.
As far as foundation, statement now comes in, one, impeachment by contradiction, but two, there's a prior inconsistent statement. As far as hearsay, Your Honor, you've already ruled that what
There's so many people. Is the me beyond?
Starting at line 1. The second score's question is, okay, so let's go back to that. Make sure I got everything right. Mikion pretty much told you it was him, Shannon, Nard, Bentley. Coleman corrects him. Nah. It was the Mikion and the D and the girl. Supposed to went to Bentley's house. This is based upon what the Mikion told him. Because you feel me? And when they got finished doing that, they supposed to pull up on him at the house. But I think the girl Bushi, you know what I mean? That's the girl who's supposed to, she know what's going on. You know what I mean? This is the girl Shannon turned against me. You remember? They came and shot at us while I was in the car. This is the girl who I thought told them that I was at the hotel with them. He's now referencing what he told the detectives about, I believe in the January 28th interview. He's now referencing what he told the detectives January 28th about Bushi potentially setting up him getting shot at on the highway.
So that helps prosecution because he proclaims he doesn't remember from one police interview to the next because they're just lies just to keep him out of jail. But yet, in an interview, he's able to reference a previous statement. If there is accuracy to that previous statement in a previous interview, then it kind of falls apart that he's lying to the police to stay out of jail because he has consistency with his statements, potentially, until you can prove otherwise, basically. Thorpe, that's his name, not Todd.
He said, nah, I don't think I had no pistol. Okay, right, but you just know what seats, how everybody was sitting in the car. All you know is Yak was driving. Yeah, I just know Yak. They said Yak was the driver. They can talk about what the Mikion. If that's based on what the Mikion told you, yeah, little D, okay. Did they say that anybody else or just in y'all circle? So nah, I told people, you did? Because I just wanted somebody to believe that I didn't do it. Yeah, I told Big Boo did it. Like, shit, boy, goddamn, they did. You know what I mean? I never know what's going to happen. I was just like, don't say nothing. Him telling me.
Wait a minute. I told people because I didn't want them to think I did it. I said other people did it because I didn't want them to think I did.
The Thorpe says, so it's Yak driving, Shannon with an AK, Nard with a pistol, and Duop with a pistol? He said, nah, I don't think Duop had no pistol. Okay, right, but you just know what seats, how everybody was sitting in the car. All you know is Yak was driving. Yeah, I just know Yak. They said Yak was the driver. They can talk about with the Mikion. They said that's based on what the Mikion told you? Yeah, little D? Okay. Did they say that anybody else or just in y'all circle? So nah, I told people, you did? Because I just wanted somebody to believe that I didn't do it. Yeah, I told Big Boo did it. Like, shit, boy, goddamn, they did. You know what I mean? I never know what's going to happen. I was just like.
So now you have him in the police statement stating that he has lied to others that he didn't do it, or that it was someone else who did it so that they didn't think he's the one who did it.
Like, shit, boy, goddamn,
he should have just
I never
pled the fifth.
I was just like, don't say that.
And left it there.
But I think that y'all, I could share this with baby herself.
Indiscernible is indiscernible. This is why I really don't like her inserting facts. I don't like it. I mean, it's not, but I don't like it.
Yes, his baby mama's not sister. And you know what? You know what she told him? What? How could you be around him and he's supposed to kill my brother? And Bentley said, if you feel like he killed your brother, just let me know. One call is on. That's why me and Bentley fell out. You know what I mean? So again, he's offering that comment to say this is why him and Bentley fell out. Then he says, you know what I mean? Like, you don't let nobody tell you no shit like that. Nigga, I ain't had nothing to do with that nigga getting killed. Detective Thorpe, because I'm gonna make a phone call, Detective Thorpe actually leaves the room. And then Kenneth Copeland continued to say, you feel me? So when I tell Bentley that, bro, you sitting around here telling this girl if she want me dead, just say it, and they go, you know what I mean? So I believe when you're saying it, they would kill me to get it off of him. And then he goes and say, I told her that, and Doug's like, nah, he's just trying to throw her off. You know what I mean? Hell no, I ain't going. So, Your Honor, the hearsay portion that the defense counsel is claiming is hearsay is not. It is the co-conspirator statement of Demetrius Garlington when he told Mr. Copeland what happened the night of the murder. And we have laid the foundation to introduce that because we asked Mr. Copeland here in court, what did you all talk about the murder when the three of you got in the car? He says no. So this is a complete contradiction to that first assertion. So foundationally, it gets to come in as impeachment by prior consistent statement. It is not hearsay because the court has already ruled that what the BTI told Mr. Copeland is a co-conspirator statement. And that really ends on page 489.
Mm-hmm. Yeah, so she gets it in. I think that is.
I told anything that the Mikian told Copeland is from page 488, where the technical was trying to clarify what Copeland said the Mikian told him, and that goes all the way to page 489, line 12. And Thorpe confirms multiple times this is based upon what the Mikian told you, and he says yeah. So again, this is the co-conspirator hearsay. After line 14, that's when he begins on page
Co-conspirator hearsay.
That goes into about it, without saying I told Big about it. Not to say anything. That's page 489, line 14, page 489, line 24. Then page 490, this is Copeland telling the detectives that he thinks Shannon told the baby.
Speculation.
And he's saying that people knew about murder, so his thought is that maybe Shannon told the baby. Now that is speculation. The state has no objection to taking out that portion.
Take it out.
Page 490.
Yeah. Yeah. Because so there are several let's see. Let me see if I can show you. There are several hearsay exceptions. But once again, it's relative to your state. So be careful about that. Prior inconsistent statements would be an exception, meaning that the hearsay, so the rule is if it's hearsay, it's not evidence. You cannot present it as evidence. Certain exceptions allow you to present it. So prior inconsistent statement will allow for hearsay. Okay, so evidence of a statement made by a witness is not made inadmissible by the hearsay rule if the statement is inconsistent with his testimony at the hearing and is offered in compliance with Section 770. This is a California evidence code. So you would need to look at evidence codes for your state that would relate to hearsay. Past recollection recorded, right? Evidence stated previously by a witness is not made inadmissible by the hearsay rule if the statement would have been admissible if made by him while testifying. So statements to the cops, they're admissible because these are the statements you would be making under a penalty of perjury, right? So the statement concerns a matter as to which the witness has insufficient present recollection to enable him to testify fully and accurately. The statement is contained in writing, which was made at a time when the fact recorded in writing actually occurred or was fresh to the witness's memory. So the fast and cheeky way of, I don't remember what I said because I lied all the time to the police, just allows them to bring in hearsay records and hearsay information because he doesn't remember. So guess what? We have things recorded that are closer in time. So we can prove that this is what you said. And so there you go, hearsay admissions, spontaneous statements. And so there's all kinds of different ones for the exceptions under prior statements. And then co-conspirator admissions. So anyone who is considered a co-conspirator, those hearsay statements are admissible. So evidence of a statement offered against a party is not made admissible by the hearsay rule if the statement was made by the declarant, which is the person who's saying the statement, while participating in a conspiracy to commit a crime or civil wrong and in furtherance of the objective of that conspiracy. So that's like planning the conspiracy, conducting the crime, covering it up, all of those elements, in furtherance. So not just the conspiracy in and of itself, but everything that would surround it. Previous conspiracy and then the covering it up. And so this co-conspirators admissions and all of that factors brings this in. So Mr. Adams does a great job at pointing out certain factors to get some of it redacted. Madam Hilton does a great job at, asserting what the exceptions are relative to hearsay. I presume that Georgia's hearsay exceptions are comparable to that of California. So I apologize. I don't deal with Georgia, but I know California a little bit. So I know where hearsay exceptions lie. But in the evidence code, that's where you would find it for whatever state you're in. And then Madam Hilton is doing a good job at making sure to bring to the court's attention foundation is laid because he doesn't remember. And this is why his assertion of Fifth Amendment right might have been more helpful to him because now he's now in a problematic state because of the inconsistencies. And now all this other stuff comes in and it actually speaks against all defendants because all this other hearsay and collective evidence that he gave prior now becomes more relevant to the case and gets to come into the jury's presence. Oh, there goes Steele. He's in the back. Because of speculation.
Copeland picks up stating that at line 15, 490, that his baby mama is Nutt's sister, referring to OG Billy. And he goes in to say, what she told him? What? How could you be around him? And he's supposed to kill my brother. And Bentley makes his comment, like, if you feel like he killed your brother, just let me know. One calling and so on. That's why. Okay, just back up a second. Sorry. About Nutt's. What is he referencing? He's referencing Mr. Donovan Thompson's sister, who is also the mother of one of Calvin Treadwell's children. Your testimony. Yes. Okay. All right. And it's not hearsay because he's given his reason why him and Bentley fell out. So he's saying, he being Copeland, is saying that the sister, in a conversation with her child's father, is saying, how could you be around him? I mean, how could you be around Copeland if Copeland's supposed to kill my brother? And then Bentley's response to that was, if you feel like he killed your brother, just let me know. One calling and so on. Copeland saying that conversation is the reason why he and Bentley are no longer friends. And that furthermore, he says to Bentley, why would you let her say that to you? If you know that's not true, you had nothing to do with him getting killed, him being down and getting killed. And he also tells Bentley, bro, you sitting around here telling this girl she wants me dead, just say it. So, I believe when y'all were saying they would have killed me to get it off of him. And then he Copeland tells Thug about the conversation of Bentley with his girlfriend. And Thug's response to that was, he's just trying to throw her off. Like, don't worry about that, Steve.
So I do not follow this trial, even though we've been in court for a few times now, right? I do not follow this trial. I don't have 93 days of time or whatever days of time to commit to the trial. So I respect those that have made a concerted effort to stay committed to all aspects of the case. But hearing the exchange of these text messages gives me some indication as to what the prosecution is under the belief the facts to be. Sounds like Nutt is actually Donovan, who is the one who has been murdered. His sister is the mother of a child. I don't like baby mama. I don't know why they would say that in court. It's usually disparaging, but the mother of Bentley's children or child. So consequently, she and Bentley have a romantic relationship, at least at one point in time. And she's questioning him for being friends with the witness Copeland, which is also known as Little Woody, because she believes Little Woody was the one who killed her brother Nutt, who is Donovan Thomas Jr. However, Little Woody takes issue with Bentley because instead of him saying, nah, he wouldn't have done that, that's not his character, he didn't do it, or defend him in any kind of way, he just professes to her, if you believe that this in fact did occur, just let me know and I'll handle it, for whatever that's worth. So the witness Copeland is upset about Bentley's position because in this exchange, it sounds like Bentley is the one that killed her brother. And he feels like Bentley is trying to pin it on Copeland. And so to get reprieve or support, he speaks with Mr. Williams, Jeffrey Williams, aka Young Thug. And his response is, oh, don't worry about it. He's just trying to throw her off because the idea is that he's the one who killed Donovan, and he's throwing off his girlfriend because he doesn't want, or the mother of his child, because he doesn't want her to get wind that in fact her love is, or the father of her child is the one who killed the uncle that killed her brother. That is what this exchange means. Very, very raveled, huh? Very tangled, but that's what it means. I think it's relevant too. I think it's relevant in the instance that Copeland is not the murderer of Donovan, even though his ex parte statement sounds like he very well may have been. It also has relevance that there is belief that the actual murderer is someone named Bentley, but that still is not Jeffrey Williams. So, okay.
All right.
Excuse me. This is the video timing. I don't know that that's actually relevant to us. I mean, because I'm not going to write it down. I'm not going to keep up with it.
It's 40. We'll change 40.
5:32.
So that's hour, 2 minutes, a second.
Approximately 5:35.
Okay.
36:13.
Mm-hmm.
Okay.
So before night, we'll just discuss it. Plus one, and that would be 490. Line 15.
Okay.
That would go all the way through page 491, line 16.
This is tedious. That's why I'm trying to skip it. Substantive.
That's Madam Prosecutor quoted from her first examination of Mr. Copeland in asserting that they had laid the foundation to teach him with specifics of this statement. The last question that I heard after Mr. Copeland says, I blanked out, is where he's asked about whether in a phone call that he receives or in the car, that's very specific, was there any discussion about Nutt's murder? Right?
That was on stand.
Right. When
He was on stand earlier.
Right. Okay. That's as far as the questioning goes in terms of any details. Right? Now, if you look at the transcript, and if you listen to his statement, there's no indication as to the information that he's relaying that he got from the Deacon or anyone else when he got that information. So I would agree, right? I'm going to be as objective as I can here and say that if the state had gone further in their questioning, right, and say, okay, well, what about later on? Was there did y'all meet anywhere? Did y'all talk about this at any point after that? But they were very specific, and they ended at the last question about what he knew about Nutt's murder was in a phone call or in the car. And so it is clear in my reading from the transcript that Mr. Copeland is referencing other conversations that take place at other times, and they can't simply say that, well, this is impeachment by contradiction based on the answer to those two questions. And so I think that there's additional foundation that needs to be laid before they can simply just kind of throw this entire statement in there.
Okay. So let's see if we can follow Mr. Adams on down his road. As he presents, he is stating that in the testimony of Mr. Copeland, in trial on the stand, the encounter with direct examination was you picked up, I guess it was Little D and Shannon, all these people. This is like, the McDonald's thing that he really doesn't want to answer. He doesn't want to talk about it. But anyway, she proceeds to say, what was the conversation? What did you guys talk about? What did you guys do in the car at that time? Because he picked them up in the car. And his response was, I blanked out. So he doesn't know. He doesn't have recollection of it. And that is one of the exceptions that we just read relative to hearsay is lack of recollection. So if you have something in writing that gives recollection to, or gives that is a hearsay statement, but it's, in writing closer to in time to when the event supposedly occurred, that when you get to the stand and you don't recall anymore, they can bring forth, things that are hearsay to help with recollection, which is why she's saying we've laid foundation to bring this in because we can play this because he doesn't recall. Well, Mr. Adams is saying, no, Madam ADA and Your Honor, you only asked about the encounter in the car for which he didn't recall. That's his black. He blanks out in the car relative to what else happened. What else did they do? You did not ask him if he had any other type of communication relative to this murder, whether it was in the car or on the phone. And the reason why he's parsing that is because it sounds like the exchange that she was reading from, the transcript, has something to do with being on the phone, having a communication maybe outside of the car that day from the McDonald's, not necessarily all at that day, maybe not in the car, maybe that day later at a different location. So what Mr. Adams is saying is you didn't probe beyond the car. He blacked out from the car. He doesn't recall what else happened in the car. But from the statement that you're trying to bring in, this doesn't sound like it was in the car to begin with. It was somewhere else by phone or in different encounters of communication. So consequently, your foundation is not laid because you did not probe into other instances this communication came about based upon the evidence you already knew, which is the police report. So that's what he's trying to argue. It's a good argument. It just, I don't think it's going to prevent it from coming in. I don't. It's good. He's doing a great job. I'm not saying he's wrong. I just don't think it's going to stop it.
But they can throw this entire statement in there.
Which, I mean, Compton standing aspect, but may not be necessary.
Line 15. There you go. The entire conversation is what her sister, who's not a co-defendant, what her conversation is with Bentley, who's not a co-defendant. Right? And to say that the reason we want that here, that is clearly hearsay. Copeland's relaying what he knows about a conversation between two other people, not even him. He's not party to that conversation. Right? He hears about that conversation, so he's relaying what he heard about what he heard there, and statements are made by Nutt's sister and Bentley.
So think about this. I mean, the defense attorney Adams he's got to work with the evidence he has. He has to work with the tools he has, but really think, because just to be objective, truthfully, we don't care if it was a true statement or not. It's, did Copeland rely on that statement? And he does, because he responds to it by going to talk to Mr. Jeffries, according to him. I mean, Mr. Williams, I'm sorry, Jeffrey Williams, aka Young Thug. He goes to talk to him and say, hey, Bentley didn't defend me and protect me. He has this girl out here thinking I killed her brother. And Mr. Williams responds with, don't trip. He's just trying to, throw her off, keep her, off his scent as being, the person who did it. So what Adams is arguing now is the conversation between Bentley and a mother of his child are by third parties that are not a part of the case, and that is hearsay. And they should be before the court as witnesses to testify if this is in fact what they said or didn't say. However, I'm sure it's not offered for the truth. It's only offered to, deal with what did Copeland do and what did defendant Williams do? How did they take the information? What did they believe upon it? What were their steps? Not if it was true that these two individuals had that precise conversation or not. Just believing that they had that conversation. What did Copeland do and what did Williams do? But it is hearsay, but exception. That's the point. That's the exception.
transcript as well, yeah, about what is being said, but why wouldn't that fall under that issue effect on listener where he's clearly talking about what the mother, the baby's mama, not sister, and what she told him, and then
what he does next. So I'm sorry, but this is commentary. This is when you can appreciate the judge, right? This is the time that you can say, okay, it's not all bad. Hopefully, I don't know if someone had a conversation, did a pull him by his coattail I think that happened in one trial, and I can't remember which one it was, but it was so evident that someone had to have spoken to the judge because they came back just as pristine as all get out. I don't necessarily believe that that's the case for this particular judge. He is the chief judge. I do think he has decorum and understanding. Whether he is fully compliant and implementing all aspects at all times, no, I think the ex parte has its issues. But when it comes to this particular encounter, this is a very reasonable conversation. He's listening to the arguments. He's actually hearing what is to be said. He's not cutting them off. He is appreciating contextually their thought process. He is helping to challenge them to, defend against this particular exception. You say hearsay, but there's an exception. This gives, it kind of gives more credibility to the fact that he is a judge. He knows some things, and human as he may be, the whole mobster, thing, I don't know, he may not be the mobster anymore. The jury is out, literally, so we don't know yet. We don't know what the verdict is. Let's hear Adam's argue.
That's why he invented it. Look at the relevance of that. That doesn't have anything to do with his recitation of the information he has about Hunt's murder. Right? Because those are questions that are being asked.
That's a good point. That's a great point. I didn't think about that. So Attorney Adams is saying what the state's evidence based upon this exchange of information, the evidence that they want is the reason why Bentley and Copeland have, no communication, or they fell out, is his exact words. But this is the reason why they're no longer friends, for whatever that's worth. Attorney Adams is like, so what? So what if they're friends or they're not friends? Their friendship, so what? Their friendship has nothing. The guy is dead, so the end of their friendship happened after the victim's death. This is not relevant to anything in the elements of the matter of his death. But isn't it? Doesn't it kind of play into doesn't it play into the conspiracy theory of these individuals are collectively operating, and this is the RICO element that they have fallout because of who actually committed the murder is trying to pin it on someone else, and so they have this. I don't know. But Adams makes a great point. He does. He makes a great point relative to relevance. Right. Mm-hmm.
And so for him to inject in here, this conversation between Nutt's sister and Bentley, what they said, and that's why he talked about Bentley's statement about that conversation. What information is being relayed?
What's the state's response to that? Basically 490 lines 15 through 22.
That's a good argument. That's a good point.
That's
right.
So Bentley by something
you're not a co-conspirator.
And
so why isn't he indicted if he is being stated to be the murderer of the person you say is dead? Why is he unindicted co-conspirator? Oh God. I promise you, like every high school person, everybody in the high school yearbook is the co-conspirator at this point. The unindicted co-conspirator.
He's saying to the police is Bentley and I have now fallen out. Bentley and I are no longer friends.
But so
what is telling this woman about wanting to kill me, she knows I had nothing to do with this for her. And so we're not offering it for the truth of the matter asserted as to whether or not
Well,
Maybe actually said, if you feel like you killed your brother, just let me know. One call back.
relevant,
It's the
though.
effect that that had on Mr. Copeland, and in turn, what he does with the information.
Which is
He
what?
then confronts Vicky about it, but then he also asked Thug about it as well. And that is why, to put what he did with Thug into context, that the jury needs to understand what preceded it. Not that we're offering him the truth of the matter asserted, but what preceded. But what preceded why he was upset that Mr. Bentley would even mention that to his Mr. Dr. Thompson's sister, and the fact that it upset him so much that he even mentioned it to Thug. Like, why would this co-conspirator say that he knows I have nothing to do with this murder? Why would he tell her that he would have me killed if he knows I have nothing to do with this murder? And so again, it's not being offered for the truth of the matter asserted, but it's being offered for the effect.
But where's the relevance?
And what he did with that information. I can't foundation issue again, Your Honor, regarding getting this industry.
I get her point that it's not offered for the truth of the matter, but I don't get its relevance. Maybe you can help me with that. Put that in the comment section. Do you know why it's relevant? And relevant, she's saying, it's like she's alluding to something more, but the only thing she's saying is that Copeland talks to Thug, young Thug, which I hate the fact that she just calls him Thug, but she is talking to Mr. Williams, that Mr. Copeland speaks to Mr. Williams about it. He brushes it off and is like, don't trip. He's just, flaming fire in a different direction. He's throwing the smoke elsewhere so that that the young lady is distracted. So what? What does it have to do with, why does it matter? Where's the relevance to the case? I don't see that alignment. So can you let me know if you know? Tell me. I might be interested.
Once he got into the car, he began speaking about the murder once he got into the car. And then in his initial
So he wasn't there?
He said that once Nard got into the car, they stopped talking. And then when Nard got out of the car, when they got
wait. So your witness that is saying 6 people are a gang, they do gang activity collectively, and had a gentleman murdered, wasn't there. He didn't witness the murder. It's all he heard. Someone told him. The streets was talking. That's enough for you? Oh, please tell me please tell me they have more evidence than this. Not to mention he's a known liar and you're getting ready to impeach him on lying. Like, what? So I'm sorry. Oh, that's right. They said they think he did it, so he came into the police station to clear his name. I was going to say, what did he do to get caught with drugs? And all of a sudden he knows about a murder. Like, okay. All right, lady. What is your case?
Said no. He said, I did not, which is inconsistent and in contradiction to what he told police.
Not necessarily.
In the car, he told me about the murder. He told me about what happened. And so it is, but the foundation has.
So what happened? So you took, wait, what? Hold on.
He speaking about the murder once he got. And then in his initial statement, he said that once Nard got into the car, they stopped talking. And then when Nard got out of the car, when they get to Sky House, they continued the conversation. So when I asked him, indirect, have any conversation about Nut being killed and his father in the car, he said no. He said, I did not, which is inconsistent and in contradiction to what he told police. What he told police is in the car, he told me about the murder, he told me about what happened. And so it is, but the foundation has the weight for this.
Mr. Adams, you can complete your argument. So thank you.
Well, why would you get in the car with someone and be like, hey, yo, we just murked somebody, yeah? Like, he wasn't there. He clearly can't hold water. This is improper though. Someone tap Mr. Adams on the shoulder and let him know when you're putting up your objection and the judge allows the prosecution to kind of interrupt to give clarity to a circumstance, you should not say, I've already put my objection on the floor. Let me tell you why. Because what we hear last is what we remember best. And when she got up, she was only supposed to speak to why this was not hearsay, this particular conversation. She further her response to include the foundational questions and the fact that she foundationally laid it out in direct examination. So she did not just respond to the judge's initial question, she gave full response to Mr. Adams' objection. So I think it would be best practice when the judge turns back to you and say, okay, further your argument, just restate your argument. Remind the judge, there's issue with relevance. We have issue for the hearsay and foundation. The conversation of the question on direct was only specific to the car. And, there is a assumption that Mr. Woody or Mr. Copeland has responded to the car question in totality relative to the victim's murder or death. However, the state failed to explore other times of communication or other scenarios because the state only asked one question relative to several witnesses being in the car who may or may not have been present. So based upon the state's question being compound and not concise, therein lies some potential confusion by the witness as to what they were asking. And quite honestly, the foundation is not there. It needs to be further explored. I don't care what you say, but whatever you say, let your voice be the last voice. Let your argument be the last argument heard. When you are allowed to go last, you have the upper hand. Let's think about that. Those of us who paid attention to the Karen Reed, Massachusetts versus Karen Reed trial. We're on jury watch, right? We're losing our minds trying to find out what is the verdict and why do you have so many questions? Because not guilty is just like the very first thing, but whatever. You will remember that the defense did their closing argument first because the burden of proof is on the prosecution. So the prosecution was allowed to give their closing last and there was no rebuttal. That was the format for closing. The last word, the last orator, the last declarant, the last speaker has the upper hand because the retention is easier for what was last spoken. So never give up the opportunity to speak. If you are asked by the judge and all you can do is restate, then restate. But don't say, I've already stated it. No. Restate it. Make it permanent. Make it ring in his head so he can rule in your favor. Come on, yes.
I still don't think that's it.
Thank you. Let's do it.
Question asked on the record such that what would be played in this would be impeached by contradiction. And also, I've got to say, I reject the thought going back a little bit to the other argument.
That's right. There we go. Thank you for tapping his shoulder. Good job. I don't know who did it, but good job. You tapped him. You got him. Got him to come. Wake up. Everybody, yes, everybody.
Their name is referenced. They have a conversation about it. If they were around or something happened, they're under that conspiracy. So they
that's what I just said. It's like pull out the yearbook and everybody is an unindicted co-conspirator. Like it's as if to say, if you lived in the zip code, is this like the new form of redlining? Like, are we red? Oh my God, no. Is this gentrification in the wrong direction? All those on this one block are co-conspirators, unindicted co-conspirators. Like there has to be a cutoff. Tell me more, Mr. Adams. Tell me more.
That's conversation about it. If they were around or something happened, they're unindicted co-conspirators. So and I reject that. If they believe that Bentley was involved in the commission of nuts, really could be indicted and charged just as a co-defendant as opposed to what they're arguing now as an unindicted co-conspirator.
Exactly.
So, the rest of the argument ask you that he's not get down. Okay.
I like that argument, but he's gonna lose. He did a good job.
That's murder based on what we heard, like things like fines, something that's check.
Relevance.
testimony. It's direct. He says, submission. That's what happened in the car. Or like words to that effect. I can't say the exact words, but it's of the opinion that the state has as a predicate foundation to explore the first code impeachment, police impeachment, my conviction. State to play that portion. Objection. Mr. Adams, I would give Mr. Continued objection.
So basically, prosecution gets everything they want. And, you know, because there were the stipulations that certain evidence could be redacted by the prosecution's acquiescence. Yeah, okay, that's not a problem. We can redact that, but not based upon evidentiary procedure, if you will. And the objections that were overruled because of hearsay exceptions and the fact that bringing in such statements are necessary for impeachment purposes due to inconsistent statements, as well as not statements being offered for the truth, but just to speak to the witness's response, what the witness ends up doing. So consequently, they're getting their evidence in based upon evidentiary hearsay exceptions. This is where, when the judge says, you don't like my ruling, you can't just do a motion to recuse me and then I'm recused because you just don't like my ruling. Like, the case moves on. You know, take it up with appeal. This is that kind of moment where evidentiary, you can say, I don't find relevance to this particular hearsay, and I'm overruled because they're saying the hearsay exception applies, but what's the relevance of this particular information? And, you know, he only speaks to foundation. I think Adams does purport relevance at some point, but when the judge is summarizing his ruling, he doesn't speak relevance. He just talks about other elements that they objected to for purposes of his ruling. But anyway, that's the kind of thing that you would take up on appeal. And that's what the judge was relying upon when he was talking about the Baptiste case, that you can't just stop the trial because you don't agree with the ruling. These are rulings. This right here is a ruling. The ex parte hearing, judge, please let us know what was the ruling. We didn't get it. We don't know what you ruled.
The next one is page 99, line 500 line.
Oh. Yeah. Okay, so I saw this part just a little bit, and I just want to give a shout out to people. You have the right to remain silent until you know, do you have an attorney present? Exercise that right. It's a very important right. It's a very important right. Very important right. All your rights are important. Know your rights, but you have the right to remain silent, because anything and everything that you say and or do can be used against you. The police officers, and that's when you're in custody. So he was coming in probably as a witness. I don't think he was in custody. He probably didn't get Mirandized. But you have a right to shut up. It's a hard thing, right? We're YouTubing it away. We're talking, we are pausing, and I'm talking, and it's like, girl, shut up, right? You're telling me I have the right to remain silent, and I'm telling you I have my First Amendment right to say what I want to say. Okay, so touche, I got you. I have the right to shut up. But truthfully, in all fairness, being cheeky, but everyone, remember you have that right. And exercising that right can be very important to the fate of your future. Because if you get in the back of a police car and you're not arrested, but you're being detained in the back of a police car because they're running your license or whatever, and you start admitting to crimes and you're being recorded, they can use that against you. So even if you're talking to yourself, like I'm talking to myself, shut up. You have the right to remain silent. The other thing is, police officers are your besties. when they want information from you. They play the role. They don't have to tell you the truth. They can lie to you to see what you tell them. You're not supposed to lie to them, but they can lie to you to see what you tell them. Now, if you lie to a federal officer, then that is, I think it's a felony, but you basically, I know for sure that you can be prosecuted for it. It's a crime. I don't think that's true for state troopers or other officers, but don't test the theory, okay? This is not legal advice. This is just suggestion. And for all legal advice, consult the attorney appropriate. But nevertheless, or in addition to, not but, because I don't negate that, I stand by that previous statement. In addition to that previous statement, I say to you, knowing your rights independently, exercising those rights at any given time and at all times is highly important, because police officers will befriend you, and you're just like, yeah, just don't arrest me. And that's the way Copeland said. He said, I say anything so I don't go to jail. Now, Mr. Adams is going to talk about an exchange where this officer does a lot of testifying. I don't know if he is restating what Copeland says or if he is just inserting facts and seeing if Copeland agrees. However, open-ended questions are much more appropriate for getting testimony from a witness versus you asserting some type of context and they responding, yes, that's correct. To me, that loses reliability and can be highly problematic, because you may agree to one part of the statement, but the other part you're not really sure on, but now you have accepted the whole statement as a collection. So Mr. Adams is going to give us an example of that. So that's what this is.
About how Mr. Williams is using others for his brain power, and how Mr. Williams eliminates people. Line 14.
Page 199.
Page 199, yes, sir. Dennis is talking. He says, you want to know the stuff. So we're just making music. I rap music. I like some loves music. I think that says every now and then. This is called Testify. This goes on and says, but that ain't what's going on. That's a fake. Other stuff. That's a detective talking. There's a Copeland response. It didn't start. Got and then detective.
That's the problem. So the detective is probably like, well, I guess the video will play at some point, and if you watch it, you'll see it once they get Copeland on the stand and they play that. But it sounds like, to me, the detective is kind of like buddying with Copeland, like, just, I like rap music. I like some of your music. Music is good. If that's all you guys were doing, we wouldn't have a problem. Well, we have a problem with all of the illegal activity. And I think he prefaces it as other stuff. The other stuff is the problem. And he's like, and Copeland's like, yeah, that didn't start until Young Thug came along. So, what didn't start? Rap music? The rap music that he likes? No, he has now agreed that the other stuff, which is undefined, I think, I'll go back and see if that's what I actually heard, but it sounded like he said, the other stuff. And now Copeland says, yeah, that didn't happen until Young Thug, Mr. Williams came along, because now that's how Mr. Williams is number one. He is the supposed leader. There is a statement by Copeland that the other stuff that the police do not like, it has nothing to do with rap music production, is because of Mr. Williams' involvement with these individuals. And that's why the right to remain silent. It's such a great right.
This Copeland Testify. Dennis goes on and says, but that ain't what's going on.
I want to hear.
We're just making music. I like Thug's music. I think that says every now and then. Transcript says has it. This Copeland Testify here. Dennis goes on and says, but that ain't what's going on. That's a fake card for indiscernible. All this other stuff. That's the detective talking in his opinion.
And not to mention indiscernible. Indiscernible, all this other stuff.
Mr. Copeland responds, it didn't start until we got Thug. Then Detective Dennis responds, exactly. Y'all as his gunners to help him get this brain of power, get out of the way. You're a threat. Anybody that's a threat, he eliminates them, eliminates them. So at what point do y'all figure out that y'all can be eliminated too? You don't care about nobody but himself. What it sounds.
So what the detective just did? So the detective became friends with Mr. Copeland by saying, I like your music. He was vague as to other stuff, but he has gotten the witness to ascribe negative behaviors or activity that cops don't like, being other stuff, is what the defendant brings to the table when it comes to the group. He is the reason for it. And now, beyond that, the detective has gone into, he is using you guys as pantsies to do his bidding, and you guys are getting blamed for it and or killed, because Donovan, the gentleman who is murdered and dead, the victim, he was an adversary that supposedly Mr. Williams didn't like, needed to move out the way. Now he's moved out the way. When do you realize that when he doesn't care for you anymore and you become an issue, he will just move you out the way in the same way that he moved Donovan out the way? So now he has befriended Copeland and turned him into, given him the idea that he can potentially become a victim too, just like Donovan was a victim. And you also have this other understanding that Copeland knows that, or feels that people are willing to pin this particular murder on him, for which he doesn't feel he had any involvement in during that time frame. Whereas we found out the other day, he's very much willing to say he was completely involved. But nonetheless, that's what the detective did. Very crafty, right? So why talk? Why talk? Because truthfully, this is the whole point. Anything and everything you say can and will be used against you in a court of law. This information is going to be used against him in this court of law. This is what this means. So, friend, no, sir, I have no comment to make without my attorney present.
Ms. Copeland says, oh, well, that's what it is. That the dentist says, so why would you stick around and let this man bring to your demise? So I'm going to go back to some things I say often. Sounds to me like it seems to me, but this is easy, right? They disagree. But this is Detective, none of this is relevant. The detective's thinking about, what Mr. Williams' music means or what type of.
The problem with that, Mr. Adams, is that the witness accepts and confirms. That is the issue. The witness is okay. And then he says, none of this happens until young Thug comes around, becomes a part. So it would be great if he said nothing. Then we could say, hey, the orator of these detectives and their opinions are not facts and they're not a part of the case. So, Your Honor, they should not be taken into consideration. But the witness confirms them. That's your problem. It's not, except the witness makes it relevant. The witness makes it relevant. It wasn't before, but the witness agrees.
And in the commentary, again, the detective opinion has just a big foundation. But getting this case, that's what he thinks.
I agree. Too bad the witness said what he said. Too bad the witness accepted it. Too bad the witness was there. Too bad the witness is recorded being like, okay, yeah, it's because of that. Too bad of that. Because truthfully, you're right. Yep. Right. There's no probe. He's just getting confirmation. He gets confirmation from the witness. It's a major problem. You need to attack the credibility.
No living ever process food for every single meal of their life.
You need to attack. I would attack the credibility of the witness. The witness is incredible. He is not credible. He's a liar. He admits to lying. He's proven to lie. They're impeaching him for lying. Why trust anything he's said ever?
State,
What's your best offense?
page 49, page 6 of 500.
Page 6 of 500 or
Page 500, line 6, I'm sorry. So page 499 and line 23. And it's exactly, he basically showed us the gunners. Page 500, line 6.
Mhm.
okay. Tell me why I should
Objection to that portion of everything.
the line 22 of page 499,
So line 23.
line 23 of page 499. So
Yes, through line 6 of page 500.
to page
Okay,
501.
well, that's good.
The
They're
state has no
gonna
objection to that.
Okay, let's talk about
agree. I don't know what the statement is though.
Is that it's still investigated in the Senate. They're still talking about Copeland's kind of concerned still about being labeled a bitch. And who, you know, even in the face of what do I do? If I tell,
You are
then
snitching.
the streets aren't gonna like me. If I don't tell, this could happen to me.
Okay.
And what the detective then says to him is, we want this stuff to stop. If y'all were just making music, I like rap music, I like some of Thug's music every now and then. Copeland says, yeah, but that ain't what's going on. There's a fake card, all this other stuff. And then Copeland says, it didn't start until we got with Thug. This line is in direct contradiction to the defense's assertion in opening that the focus of their investigation was all about Young Thug and his music.
So the concession that they gave was that when are you guys going to realize that you guys are the gunners, and that what Young Thug does is move people out the way like Donovan, and that can happen to you. They're conceding to redacting that part, but all of the witnesses acquiescence to the detective's assertions become evidentiary because he is supporting it, and he's saying, yeah, it didn't happen until Young Thug. However, all this other stuff is like what? The Grammy, the awards, the obviously that's not what the other stuff is referring to, but when things are not defined, admission of guilt, you silence, just have your attorney come so your attorney can say, no, don't answer that.
This assertion in opening that the focus of their investigation was all about Young Thug and his music. That we attacked as a state, as the police officers, that we were only focused on using these lyrics and this music, and then we created a case solely based off of the music. And this is a direct contradiction to that. In the course of
I
the
don't know about that,
investigation,
but
the
okay.
investigator Dennis is telling me, Mr. Copeland, this is not even about the music. Matter of fact, I like some of his music. This is about what has been happening in the streets, what the shootings that have been going back and forth for now, at this point, 6 months, and putting an end to that, and encouraging Copeland to continue to tell the truth about what has happened. And then Copeland's response to that is, this didn't start until we got with Thug, until he, I believe the we is him, the Mikian and Shannon, that all of this violent stuff started happening. And it's not just about the music. And so we believe that this is in direct contradiction to the assertion that the police officers were so focused on.
Did you just see her define all this other stuff? You just see her define we. This is why you stay silent, because definitions for what you may think you're saying, if you don't completely define and be precise and concise about what you're saying, can be interpreted into meaning something altogether different or expansively different. And consequently, you find yourself in court getting ready to be impeached, and folks are going to jail because stuff.
This is a direct contradiction to the assertion that the police officers were so focused on music and lyrics in this case, but no, they were focused on stopping crime. It had nothing to do with it. So for those reasons, Your Honor, we believe that that portion is relevant.
Yeah.
What is said in opening, not evidence. Questions by the attorneys aimed at getting a certain point, not evidence. And so what they have to prove in court, they have to prove by way of evidence. What the detective says in this excerpt, we're talking strictly about line 15.
Take a look at some security device, because that's Elon Musk's latest event. He's been warning everyone
through line 22.
The worst part about the ads is it's so hard to cut them.
What they have to prove in court, they have to prove by way of evidence. What the detective says in this excerpt, and we're talking strictly about line 14 through line 22. This is the detective's opinion on what the music is or is not. So, for example, if you look at line 19, when he says, "But that ain't what's going on. That's a fake card for all this other stuff." Well, if that's the case, then let's prove it with evidence as opposed to giving the jury the detective's opinion as to what that is. Because without more, what the jury ends up getting is the detective's soliloquy on what he thinks the music means, whether or not it's being propagated for,
and what the witness agrees to. That's the problem.
I just don't think there's anything. I think it's in regards to this. And I think there's a fair amount of speculation on the stage. But again, I understand they have the issue. But when the prosecutor says that Mr. Copeland's response, it didn't, on line 22, it didn't start until we got when she opines, well, when he says we, he means Shannon and the Deacon, and this is who he means. Well, they don't know that. They don't know that any more than we do, unless Mr. Copeland gets on the stand and says, hey, this is what I meant. This is what I'm talking about. But it hasn't happened yet. So that part is speculation. But overall, it's nothing but that detective speculation. That's what we get to do.
Right. Yeah, you're right. She filled in the blanks. She made definitions of words that weren't necessarily defined unless they are somewhere else in the transcript, not yet read. But basically she said, this is what I believe we stood for. And she went into what the stuff is defined as, but it's up to the witness to speak to what their belief was and what they witnessed and what they defined the stuff as. And so foundationally, she should have asked those questions, or I guess that's what she's going to try and do relative to bringing in the evidence. But that's, it just goes back to what I said. I just feel that though his arguments are great, that this is very much a soliloquy based on an epithet relative to these detectives' opinions. The witness asserts agreement and puts blame to his client. If you say nothing, then it's just an opine by, a non-witness and a speculation by, a YouTuber. You know what I mean? Like it's a nothing burger. But when your witness is like, yeah, wasn't like that until Young Thug came along. Problem.
Sure. The state is making the argument that this out-of-court statement should be played because of arguments that some defense counsel made during opening statements. My recollection is that certainly that Investigator Dennis has been on the stand, and he provided live testimony regarding the defense argument about following lyrics, and instead said, no, we follow crime and it found lyrics. I believe that was Dennis and Anna Gay. Anyways, the state has provided live testimony regarding that issue and their counter to whatever was argued in opening that they say was argued in opening. So I don't know why we would, knowing that it's been argued through live testimony, I don't know why we would allow out-of-court statements, hearsay statements that also have problematic parts in speculation, as Mr. Adams has stated. I don't know why we would allow that into evidence when the state has already been allowed through live testimony to address this issue.
Okay, good point. Okay, so a lot is being said right now. Basically, affirmation that it is not the burden of the defense to present evidence. That's not the defense's burden because it is the prosecution's burden to prove the elements of their case. And the defense, defends against it, attacks it, pokes holes in it, determines, how accurate and impartial and pure this evidence is. Can it be received as a factual piece of evidence? Is it legitimate? Has it been truly preserved? Is it rightful? Chain of custody and all those wonderful things that the defense does. But the defense is not required to present evidence because they're not suing anyone. They're not charging anyone with an offense. It is the prosecution's job to present evidence because they have the burden of proof. Defense does not have burden of proof. So you're just referencing Karen Reed once again. Mr. Jackson does a great job of giving alternate theory and presenting some evidence that can help to support an alternate theory as to what has happened to Officer O'Keefe. but that is not necessarily a responsibility of the defendant. It is a choice to do as such. So consequently, the judge has affirmed, yes, I understand that one, it's not even your responsibility to present evidence. You haven't even presented evidence. You know, you're not evidentiary bound, and you're not here for the. You don't have the burden of proof. Secondarily, opening statements are not evidence. So, and sorry to be so bottled down in the Massachusetts versus Karen Reed trial, but it just is like the most recent thing going on that I can reference on the top of my head. But if you remember, you have heard the judge in that trial to constantly say things of what the jury's responsibilities are, and to understand when reviewing text messages, can you can consider the text messages if you believe those are the true authors and that it's the likelihood that this is what they've said, or you can disregard the text messages because you don't believe that they authored the text message and you don't believe it's likely that they stated it. The other things that have been instructed upon the jury, which has application here, is that the attorneys are not testifying. So the things that the attorneys say is not evidence. It's not consideration of fact or proof. This is what the judge is affirming in this case right now. Judge Glanville is stating, I understand that, you know, I'm proficient enough to understand that the attorney statements in opening are not evidentiary. This is not evidence. Because in all intents and purposes, they're not witnesses. So that is that affirmation. This is where it has the best application, where it is also meant to be echoed is when there is cross-examination, and the cross-examination is that yes/no question that we talked about earlier, and the attorney is asking something by giving a lot of context and laying it out for the witness to say yes and no. And the reason why Alan Jackson cares not what Jen McCabe or Trooper Proctor have to say in response is because what he has said as a question has now rung a bell in the jury's minds. This is why the judge continues to state, but what the attorneys say is not evidence. What the witnesses present, what they testify to is evidence. What they present as the evidence collected in the scene and they present to the court, that in fact is evidence. And so it's funny because quite actually, it may not be evidence, but when Alan Jackson is running around talking about see you next Tuesday and the absolute deplorable behavior of Trooper Proctor and the fact that he was in search of nude pictures, though Trooper Proctor says, I just said I didn't find any yet. I didn't say I was in search of them. I just said I didn't find any yet. Matters not, because the reality is what is impressed upon the jury is that he was looking, right? Even though that's not the evidence. But this application is more clean cut, and it helps the jury, and it helps the fact finders in better clarity. The opening statements, closing statements, that's not evidence. That's why sometimes you hear objections, like we did in Depp v. Heard. A lot of objections when Elaine was speaking. I think that was the closing because those were facts, not in evidence, right? So you can't, as a attorney, start saying certain things in the closing that are not factually in evidence. So yeah, that's my epithet and my soliloquy relative to this very short statement about affirmation of knowing that opening statements are not evidence. Of course she wants to respond.
First, they cannot rebut what is opening.
That's not what they said. Not what they said. They did not say that the state cannot rebut what was stated in opening. They just said opening statements are not evidence. And I guess maybe her use of rebut is that you rebut evidence. So maybe that's her thought process. But you have an opening statement. They have an opening statement. You have a closing statement. They have a closing statement. And truthfully, are you winning your case when you're trying to defend against the defense? Like, you are with the burden of proof. You're proving a case. So you are presenting the evidence in proof of your elements and your charges and indictments against the defendants. Why are you answering the defendant's theories? Why are you rebutting theories of the defense? in your case in chief, no less. It's not like this is rebuttal. This is case in chief. I don't understand. But whatever.
621.
94-6.
621, which is impeachment by contradiction. Also in reading, Carl says on page 351, which is cited to.
Our programs include welding and metal fabrication, CAD design, and carbon fiber for aerospace and automotive.
Federal, Carl says on page 351, which is cited to federal law. Federal courts allow parties to counter misrepresentations and opponents in an opponent's opening statement with contradictory proof.
What page down, sir?
Page 351. Opponents in an opponent's opening statement with contradictory proof.
What page down, sir?
Page 351.
What part?
If you go to,
I see it.
The sir.
Work there right now.
Yes, ma'am.
Okay.
And rebuttal will sometimes be the counter and factual assertions made during the defense counsel's opening statement or for the cross-examination of the government witnesses. So the state can bring in evidence to rebut what was said in an opening statement. But furthermore, Your Honor, this statement, what investigator Dennis said about the music is an adopted admission by Mr. Copeland. Mr. Copeland does not disavow that this is just about making music. He, matter of fact, agrees with Detective Dennis. And in court, Your Honor, Mr. Copeland made it seem that YSL is just a music group. Matter of fact, I think he even said the only gang that he associates himself is 372. That he's not even a part of YSL. When I asked him directly, "Are you a part of YSL gang?" and he disavowed that. So when you look at what he testified in support about his disavowal of YSL, that YSL is just a music group, that this is a direct contradiction to that assertion he adopts what Detective Dennis says by not disavowing it, not saying, no, it's only about the music. He says, yeah. And matter of fact, he further says, it didn't start until we got with Thug. So, Your Honor, for those additional reasons of this portion, page 499.
We got with Thug or we got Thug? That's what the transcript says. We got Thug.
I think when you listen to the recording, it says until we got with Thug.
Let me listen to that portion because
But here's the other thing. Here's the other thing. Maybe okay. So that was a good federal citation that she did for rebutting opening statements. Does not mean that opening statements are evidentiary, but good citation for that. But for Copeland making the statement that he's not with YSL, a gang, and it's only about the music on the stand, could very well still remain true because his statements to the police officer is the extra activity comes into play when an additional person comes along. And he may very well feel like, hey, I'm not a part of all that. I'm a part of the music part. That's my play. That's my role. And whatever that could be, that has nothing to do with me. And that's relative to the defendant, Mr. Williams. So let's hear a bit. Let's hear a bit to get clarity of records. What? I thought that was the best part of, I thought that was the only best part of the reason why this would be admissible was because he adopts admission to when he says, yeah, and it only started to happen when Young Thug got involved. And the judge disagrees. See, I'm wrong. Look at this. Life teaches us things. Okay, so which I think Mr. Adams is saying is that in response to her federal citation, that it has to do with witness rebuttal and not the opening statements of theory, that the theory does not get rebutted if they state that a witness is going to say something and a witness is going to prove something, that you can rebut a witness. I think that is what Adams is saying. I'll look it up maybe if I have enough energy later, but let's go ahead and hear what the interview is, the clip. And be careful with your ears. No idea what this is going to sound like. No idea. It's going to be what it's going to be. Be careful. It might be loud. It might be crazy. It might be muffled. It might be low. Protect your ears. Okay. I'm sorry. Is this loud? Wait a minute, is this fast? Okay, let's slow this down. I'm gonna bring this down just a bit so I can hear his words. Oh, okay. Let's see if the closed caption can help us. I want to slow it down anymore because that may sound real weird. Let's try this again. Oh, geez. Okay. So I think he's saying that someone is trying to alert people that he is talking to the police, but they don't necessarily believe that alertion because there are no warrants, no one's getting arrested. So if he was in fact talking to the police, they would be getting arrested. Okay, guess what? Detective work takes time. 48 hours is great. It's great. It's great. But there are some and a great majority of cases that are cold cases or that take years or a lot of time for development, even if you do have someone who is an informant. So that's a ill-advised position to take, that you don't have a snitch among you just because no one's arrested. How about just don't be a criminal? Okay, let's just not be criminals, and then we don't have to worry about snitches, right? He's very general. Everybody's saying, everybody does, stuff and all. Understand how this is the piece. Okay, so this is not even the piece of reference. I'm like, we're supposed to be talking about music and when Thug gets involved. So here's another issue. Well, I'll just let them try and find it. Here's another thing. She's given out all these timestamps, but yet who's going to confirm that her timestamps are correct? What's that? So now hearing the yeah is not admission of guilt. The yeah is like, yeah, okay, you like music, yeah. It's like reception of your point of, like, listening to you. It's an acknowledgement that you said something and I heard you. So contextually, it sounds much different than someone reading it off the paper, which, body language, tonation, these things matter. They give context to what is being said in a way that just reading it off the paper can be interpreted so differently. It didn't start until we got the. Gosh. No, I hate these commercials. That's what I hate. Oh, watch your ears, watch your ears.
Anybody else?
That's what? That wasn't me. I'll go to sleep in a minute. So tired. Mama. Had to slow it down because of It's still unclear to me. It can be read either way.
Part of it.
Oh. Correct. Breath. Okay.
Based upon the court's
Here's his ruling.
list portion, lines 14 through 22, the court is of the opinion.
All right. What a good win. But I don't know how far that goes. Yeah, it should be. And so here's the situation with that. In civil law, we have depositions and we hire court reporters that will transcribe hearings, and consequently and they will record those deposition hearings. I'm not talking about the hearing with the court, but deposition hearings that typically happen in like a office space or sometimes a conference room at a hotel or whatever. And they will transcribe that and record it if you ask, and they'll video record it too if you request that. And the timestamp and the words, they just go all together, you know. And it's much easier for the paralegal to be able to present to the attorney. Okay, those lines are lines 17 to 19 on the transcript are 5:29 and 30 seconds to 5:33 and 10 seconds. It's very easily readily available to recount where that transcription is, where it is in the recording, so it can be played, so forth. Deposition transcripts and videography hardly ever come into court until it becomes something of an impeachment. And I think we saw, where did we see that? Was that Deputy Heard, or gosh, I can't remember where it was, but it was one of the cases, and the deponent had the blue screen behind them and they looked like they were in the weirdest, oddest place ever. And it was a deposition, and it was brought up for impeachment purpose. So the witness was live on the stand, and it was like, okay, but previously you testified to XYZ. We're going to play what you testified to. But I just can't remember what case that was. So bringing that to memory, this right here is different. So criminal attorneys and criminal paralegals, is this real? Is this how this goes? Because it almost appears as if ADA Hilton has to kind of surmise in real time how long those two lines actually take to come to a thought process of it starts at 5:44 and will end at 5:46. And if you can, make that apparent to me, I would very much appreciate some update to that, because the judge is like, you said 5:29 earlier. But I'm trying to figure out, well, how does she know? Because and if it's not on the transcript that you guys are looking at collectively, what piece of demonstrative does she have that gives her that information that she knows what lines are being cut out of the video, and who's going to confirm it prior to going before the witness? Because now she might be off elsewhere, because you had all those other places that were getting redacted. I don't know how it works in criminal law. I don't know. I don't get it.
Okay.
Okay, so they've moved on to something else. I want to go to something particular and see if I can find out about this rule. I think it was 26-6-1. I just want to double check. I'm not sure. I didn't write it down originally. Okay, she was starting it when she stood up. So come on, Hilton. Up, 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 up. Okay, it's like when she first started. So let me. It's here.
Defense counsel opening statement.
She's reading from Federal Rules of Evidence.
First, to that the state cannot rebut what is said in opening. And looking at 24-6-621, 621, which is impeachment by contradiction. Also reading Carlson on page 351, which is citing to federal law. Federal courts allow parties to counter misrepresentations and in an opponent's opening statement with contradictory proof.
What is her citations?
621. State cannot rebut what is said in opening. And looking at 24-6-621,
24-6-621,
which is impeachment by contradiction. Also in reading Carlson on page 351, which is citing to federal. Federal courts allow parties to counter misrepresentations and in an opponent's opening statement with contradictory proof.
What page down, sorry?
Page 351.
What part of it?
If you go to,
I see it.
The
Got the fourth paragraph down.
yes, Sam.
Okay.
All right, let's do a little research. Let's do a little research. Okay, so a little bit of research of what the prosecutor ADA Hilton gave as supporting evidence. So the very first thing is Georgia Code. Okay, so Georgia Code section 24-6-621. And as the judge has professed, there are changes in or frequent or more recent changes occurring within Georgia's law. Very much so. A lot of things are in the works. So this came about, it was added in 2011 and it became effective January 1st, 2013. So that's about 11 years old. Not quite old when it comes down to law. But in Georgia's code, section 24-6-621, this is the impeachment by contradiction. That is her first assertion of authority relative to her point that she's allowed to bring in this information to impeach the witness based on contradiction. And it says a witness may be impeached by disproving the facts testified to by the witness. Very generalized statement. So that was a very quick statement, and okay. But then she cited Carlson and states at page 351 about paragraph 4 and allowing rebuttal for opening. So let's talk about opening statement just a little bit. This is prosecutors for North Carolina. This is, go down to D, just to give you a kind of an understanding of what goes across the board. So opening statements, well, wait, let's go before we do that. Let's go to Carlson because that's what she actually cites. Set this one here. Okay, so opening statements. Basically every lawyer who sits down, and this is Ronald L. Carlson and Michael S. Carlson, this is an article they wrote called Making It Stick. They wrote it for I think the Georgia bar or the American bar. Looks like Georgia bar actually. Let's see, where's the School of Law, University Making It Stick. Where did they publish this one? Georgia Bar Journal. So they got this into the Georgia Bar Journal, for which you see down here. This is where they published. Okay, let's make this a little bigger. And they have a book called Carlson on Evidence. And this book is readily used for Georgia prosecutors. This is one of their go-tos. Whereas for us, it's like California Civil Procedures or Rudders, you know. So for prosecutors in Georgia, this is a part of their legal Bible, if you will. And this is just an article written by these authors based upon summation of what's in the book. So this is not the exact citation, because she cited page 351. But nonetheless, just understanding opening statements. Every lawyer who sits down to plan opening remarks for a trial has the same question: how far can I go in arguing my case during opening statement? Making one's theory of the case stick from the very start of the trial depends mightily on how far the lawyer can go in opening statement. So basically, what's allowed, what's disallowed. Visual aids, are those allowed, disallowed? Applicable law relative to criminality and what can be stated, display of trial exhibits. So they have all of that there. What becomes colorful language, you know, what is and isn't, they go into details. We don't need to get to that. What's applicable to Madam Hilton is the opening the door. So the opening the door paragraph says, a final pitfall worthy of mention is the inartful speech that allows one's opponent to open a can of worms. Assume there is a certain damaging evidence that your opponent is barred from exposing. Can you activate his right to disclose the prejudicial stuff by your own opening statement? Yes, says the Georgia courts, and examples abound. Evidence otherwise prohibited under a motion in limine, which is the procedure that suppresses certain evidence that's not allowed because you usually have hearsay and different rules of evidence. You go through the motion in limine process. This speaks to evidence that would be prohibited under that motion in limine, for example, can be introduced after an opening statement by the movement explores the prescribed topic. Similarly, the United States Court of Appeals for the 11th Circuit has ruled that in federal courts, a verbal attack by a lawyer on a witness during opening is sufficient to allow introduction of evidence on direct, which is typically only relevant after the witness's credibility has been attacked upon cross-examination. So consequently, this is a summation based upon both of what was asserted by ADA Hilton and rebutted by, or responded to, I should say, by the attorney Adams. You hear ADA Hilton say, federal courts have ruled that, the doors open per se during an opening argument. We can, as the state in our case in chief, supply rebuttal testimony or evidence to an opponent's opening statement. And then you hear Mr. Attorney Adams say, but that's relevant only to witnesses. And the judge says, yes, I see that. So this is the statement right here as to what they have confirmed, that the appeals court for the 11th Circuit has ruled that in federal courts, a verbal attack by a lawyer on a witness during opening is sufficient to allow introduction of evidence on direct, meaning during the case in chief in the direct examination, which is typically only relevant after the witness's credibility is attacked upon cross-examination. So under normal circumstances, rules of evidence would be direct, would just express, information and witness testimony to what the witness knows. Cross-examination comes in and attacks the credibility of that witness. Then you go up for rebuttal. And then you, in the rebuttal process, you restore the witness credibility. That's the normal unfolding. However, there is a ruling that says if a lawyer in their opening statement attacks the witness during the opening statement, the prosecution or the plaintiff does not have to wait for the rebuttal process. They can rebut that information, that particular attack that was in the opening. They can rebut that in their case in chief in the very beginning during direct examination. And so that's what she was asserting. And then, of course, it gets shut down because the premise is that it's if the lawyer attacks a witness and the credibility of a witness, that gets to be rebutted, not just any particular evidence. The citation for that, just in case you're curious, is the United States versus Knowles, 66 Federal 3rd District, 1146. I'm sorry, 11th Circuit, 1995. So that's number 26. United States v. Mills, 66 F 3D 1146, 11th Circuit, 1995. Okay, so that is what they cited to specifically, and then there are some more definitive understanding that is expressed through, this looks like North Carolina's Prosecutors Resource Online for Opened the Door. It kind of echoes just the same sentiment, sounds like Carlson's with regards to procedures in criminal court have high regards, especially in Georgia. But North Carolina just might be a sister state. You can see here, defense counsel's opening statement may open the door for the state to introduce evidence during trial to rebut or explain that opening statement. And they, of course, and this is what I mean when I said before, you cite your state case first, and then if you don't have your state case, then you go to federal. She went straight to federal because I guess there's no real state case for Georgia, but North Carolina has their own state case, and it's State versus Murillo, as cited in response to defense counsel's opening statement that victim was irresponsible alcoholic. State was properly permitted to offer character evidence concerning the victim's performance as school teacher. State versus Jones. And then the state was entitled to introduce this testimony by Ms. Lorden to explain this opening statement by the defendant's attorney. Now, a caution is for this particular state in North Carolina to see State versus Bowie, where finding it was in error to allow state to introduce character evidence in its case in chief to refute defendant's forecast of evidence in opening statement. So there is the careful parsing that you have that backs Attorney Adams. You are not, the state is not allowed to rebut forecast of evidence. They are allowed to rebut characterization of a witness. That is the difference. And that is explained in Carlson's article that we read originally, because closing arguments is like the wrap up. That's where the prosecutor may properly comment on the defense counsel's opening statement under normal circumstances, and defense counsel's failure to produce any particular evidence to support the assertions that were made in the opening statement. Even if the defendant does not testify, that is where the rebuttal goes to opening. The opening statement is a preview of what is to come. It's a forecast of the evidence. It's a preview of what's to come. So in your case in chief, you don't rebut the forecast of evidence. The only ability to do that for the prosecution is if it is a dispersion to the witness. If it's a character assassination of the witness, then you can clean that up in the case in chief under direct. So there we go. We've done some research. We found some things. By golly, are you tired? I'm worn out, very much worn out. So hopefully that puts it in perspective a little more, and let's take it back so we can hear the exchange in real time now that we have the actual legal context to go off of. Okay.
They cannot rebut what it said is opening. And looking at 24-6-621,
24-6.
621, which is impeachment by contradiction. Also in reading Carlson's on page 351, which is citing to federal law, federal courts allow parties to counter misrepresentations and in an opponent's opening statement with contradictory proof.
What page is that? I'm sorry.
Page 351.
What part of it?
If you go to,
Isn't that just like so amazing? I don't know if they made like a decision to what, you know, if they would adopt Carlson's book, which is Carlson's on Evidence, but he has it right next to him. This is how important this particular doctrine is. And as we saw, these are individuals that are writing for the Georgia Bar Journal. So they're highly regarded relative to their doctrine and representation as to how to present your case, what is acceptable behavior, non-acceptable behavior, and collection of case law that supports that, even if it's federal case versus Georgia cases, or the collection of both. I've seen where they've cited both laws, but in this particular citation, this is federal specific, that they are recounting I'm sorry. Yeah, recounting. Let's just move on.
Okay.
Fourth
And
paragraph.
rebuttal will sometimes be the counter and factual assertions made during defense counsel's opening statement or for the cross-examination of the government witnesses. So
I'm
the
sorry.
state can
Made
bring
it cover.
evidence to rebut what was said in an opening statement. But furthermore, Your Honor, this statement, what investigator Dennis said about the music is an adopted admission by Mr. Copeland. Mr. Copeland does not disavow that this is just about making music. He, matter of fact, agrees with Detective Dennis. And in court, if you can recall, Your Honor, Mr. Copeland made it seem that YSL is just a music group. Matter of fact, I think he even said the only gang that he associates himself is 372, that he's not even a part of YSL. When I asked him directly, are you a part of YSL, the gang? And he disavowed that. So when you look at what he's testified in support about his disavowal of YSL, that YSL is just a music group, that this is a direct contradiction to that assertion. And he adopts what Detective Dennis says by not disavowing it, not saying, no, it's only about the music. He says, yeah. And matter of fact, he further says it didn't start until we got with Thug. So, Your Honor, for those additional reasons, this portion, page 499.
We got with Doug or we got Doug? That's what this transcript says. We got Doug.
I think when you listen to the recording, it says until we got to Thug.
Let me listen to that portion because I just want to listen from about line 14 to line 22. Okay, Mr. Sharp, you have something else?
Well, it just occurs to me that this adoptive admission argument.
Don't worry about that. Don't worry about that.
Okay.
Don't worry about it. I mean, I'll let you complete your argument if you want, but I'm not convinced it's an adoptive admission. Okay.
You're not convinced?
All right.
Yeah.
Yeah. That's why I'm not convinced. Okay.
Okay. So he's not convinced because of the code in and of itself. Even though we explored the doctrine and implementation thereof. Let's see, what is the actual code here? So the code in and of itself says a witness may be impeached by disproving the facts testified to by the witness. Okay. He's not convinced, but that's what it says. We went through that, but that is the exchange between Hilton and Judge and Adams asserting the Carlson's evidence. Yeah, problem, they start off with the wrong start time. Just reviewing this real quick. And then we get the judges. So remember how she asserted that that he had? I like Thug's music, Young Thug's music every now and then. Yeah. She was emphatic with it, right? And that was the adoption of admission of guilt. Well, I was wrong. Okay. And the judge was like, no, I don't see it that way. And when we listen to it, it's clearly not that way. Tone lets us know. He's just saying, yeah, I got you. I hear you. I hear what you're saying. Yeah, okay. It's not really an adoption to say that they are nefarious in any other way. It's just receiving the fact that he likes the rap music every now and again. Okay, yeah. So that's what I take issue, where I think there's the adoption of admission, but it's not addressed. It's the judge doesn't feel as such, and very wise decision by counsel to not argue. He says, you can make the argument later. I'm not convinced that it is. And he's like, oh no, you're not convinced. There's no need for me to argue. Right? Because you argue yourself right into the wrong rabbit hole. Okay, so he plays it again. We've heard it now a couple times over. We can move right along, and let's just get the ruling to this.
Detective Dennis, 14% part of it.
He's clarifying the record.
In regards to that particular portion of what the text starts off. Okay.
Okay. So we have record clarity now ruling.
So, listening to this particular portion of lines 14 through 22, the court is of the opinion that it is opinion by Detective Dennis.
I think we have this somewhere. Mm-hmm.
Discussion in regards to that portion. Okay.
Okay, so while the court moves on to some more motion eliminate concerns or relative to evidentiary concerns as to what's going to actually be presented to the jury, I'm going to say, hey, we did it. We came to court. We learned a little bit. We did some research. We found out about Georgia law. We got some authoritative doctrine from the Carlson on evidence. And we got to see where maybe agreement can be disagreement and so forth. This is why I have said in the past, legal minds to agree is it's very hard. It's very hard to have all legal minds make an agreement on, to one simple thing, because we always look at things differently. We're trying to see different angles and different perspectives. And this is why we have case law. This is why we have codes and things that have, been agreed upon by majority, so that trial courts have a guidance to what law is implemented in the trial courts. And then, of course, appeals courts and Supreme Courts can take things up on appeals, make the changes, make the revisions that you turn around and create new precedents versus having a stare decisis case, whereas it's currently happening. It's a current change in the case that is bringing upon new law. So consequently, we've learned a lot. Got real tired. I'm sorry, got real tired. I gotta go to bed. But in this exchange, we have the appreciation of seeing that Judge Glanville is not a free-for-all for the prosecution. We have a good view that the prosecution is not continuously and always unreasonable. And I say that with quite reservation because, I'm still concerned that we have rap lyrics being a part of evidence. I'm concerned with some of the threading but I haven't seen the whole case. I've only seen snippets of it, so maybe it makes more sense to the jury. But to me, if I was a juror, I'd be looking at the prosecution like they lost their mind. You're putting up witnesses, or a witness specifically, that is a liar, is professed to be as such, and who has reported that they shall lie right here, right now, on the stand. Why are we wasting our time? But obviously, there's a lot of evidence that needs to come in through this witness. And I don't know if you have a case, and I don't know how much the jury trusts this witness, because I trust him not. But we've learned a little thing about opening statements, so hopefully that's helpful for you. All things considered, we're learning, we're watching. Hopefully we're, having a better day today than half of the defense is having, okay? So I'm Lyric Armstrong, your real estate agent and advocate. It's such a pleasure to have you in this video. I look forward to seeing you in the next video. Have a good one.